Assalamu alaikum. I'm Gina Samuel Riches, Solicitor and Director at AGR Law, and you're listening to Radio Ramadan on DAB and FM 87.7. And this is The Law Show. You can follow us on Facebook, Instagram, YouTube, LinkedIn, TikTok, Twitter, and Spotify, or any other place that you get your usual social media from. Today we have Dr. Faisal Manju, who's the CEO of Munara Consulting Limited, and he has been such since 2012. He has conducted an enormous variety of legal and financial advisory assignments in academia, ensuring that advice is given always at the vanguard of contemporary thoughts and literature. Welcome, Dr. Manju.
Thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh.
If you want to just start off telling the listeners a little bit about yourself.
Okay. I think from my accent, you'll pick it up that I'm not from UK. I got this French dominating my accent. So I was born in Mauritius, a small island where people go often for their honeymoon. And then I moved to South Africa, where I studied quite a lot. I qualified in a traditional Darul Uloom. From there, I went to university on the advice of Qazi Mujahid Islam, a very prominent scholar of India. And there I did my law degree, I did my master's, I specialized in employment law, banking law, and of course I did in family law as well, and my B honors, etc. Then I was admitted as a solicitor in UK. In UK you call it solicitor, in South Africa we call it attorney at law, by the Pretoria High Court. And then here I am in UK. I came to study, I did my PhD. Presently I'm a lecturer at a few universities, Financial Business School in Paris, Markfield Institute of Education. I'm affiliated with Al Maktoum in Scotland, which also affiliated to Dundee University, and also with the Cardiff Metropolitan University. So this is about my academia. And of course, I'm a consultant for Islamic finance. I did my PhD in that. That brief about me.
Brief, you say. You're an extremely learned man. So today we're talking about financial planning and estate planning and the other factors that would involve. And I suppose we're going to spend most of the time talking about wills. But before we talk about wills, can you explain to our listeners what estate planning is and the different factors that they might want to consider?
All right. Okay. From an Islamic point of view, we have to understand that whatever we have is a trust from Allah. Allah has given it to us. Therefore, we got to manage it according to the desires of Allah, His laws. Now, when we look at estate planning, there are two main aspects. One is the liability side and one is the asset side. Why this is important, there are various reasons. One of it is, if you don't plan it, one of the problems you may have is the inheritance tax, which can go up to 40%, the nil rate ban, etc. The second reason is what we call the intergenerational transfer of property and assets. Very, very important. The third one is to protect your own people, right? The fourth reason is, for example, if you've got a business, how do you handle that business, especially if you want to work at a multinational level? So when we talk about estate planning, is how do you match your assets and your liability and smoothly transition that to the next generation?
Thank you. And what about for why our listeners are still alive and kicking? How can they protect themselves now? Or, for example, if something happens to them, what needs to be put in place that could help them to continue living at a decent standard?
Okay. Living in the UK, I think we have to differentiate those two things. If you look at the continental law, there is what we call the mandatory heirship. That is, the law is already stipulating who will be your heirs. In the country, mainly common law countries, mainly UK, you have what you call the freedom of testation. In other words, subject to certain conditions, you are free to give whatever you have to whoever you want. So the starting point, my personal opinion, would be you write down all your assets and all your liabilities. Next stage is who you want to transfer it to. Once this is clear in your mind, is then you start drafting a will. It's sad to say, according to one of the report of the Office of National Statistics of UK, approximately 70% of British do not have a will. And if you look at the case laws the number of fight, even you have a will, you end up in the high court. That is what we try to avoid. So we have, during our lifetime, we have a duty vis-a-vis ourselves, vis-a-vis our heirs, and most importantly, vis-a-vis Allah, that we ensure that this does not go out of control. If not, if we don't have estate planning, what would happen? Our heirs will fight. And that is something we want to avoid. So the starting point, in my humble opinion, is to get an inventory of your assets and liabilities, know who are your heirs, and then you start planning. Now, when you're going to plan, this is where a lot of things will come into play. For example, you talk about will. Will is one of the main issues that we'll consider. Especially for Muslims, there are specificities that needs to be factored into the will. Number two, at times you may have trust to protect your people. Now, even trust law is a huge area of law, but we can use trust mechanism, right? There is, for example, during your lifetime, donations. You can give donations. So there are many mechanisms that we can use to really place our ducks in the row so that after our death, there is no problem.
That's good to hear. So, but as Muslims, what do we need to worry about if we die without a will? How does English law deal with our assets?
Okay. I think that's a very deep question that you have raised. First of all, we have to understand that under English law, if you have a will, it will facilitate a lot of things. And this is what our people, our listeners need to understand. If we do not have a will, then to distribute your estate, it will fall under intestacy rule. The rule of UK will apply. Who will get what? It's not according to what you want. You might have estate tax planning, which should have taken into place. The right heirs might not receive the right shares, and many other issues will come. There might be delay in distributing your estate because you got to apply to the probate to get one. The cost will go up. So that is one thing we have to understand. If we do not have a will, it will fire back on us. Now, when we have a will, that is known as testacy, that requires deep thought. Why it requires deep thought? First of all, we have to understand that living in the UK, this will is to be we got to follow the Wills Act, right? We got to follow the law of the land as well. So the Wills Act gives you specific conditions for the wills to be valid. That's the first point to understand. Number two, as Muslims, we have to understand if we don't leave a will, there will be more than 35 verses of the Quran that are not going to be upheld. And that is problematic. We are going to violate those ayat of the Quran, the hadith of Rasulullah. Who get what has already been determined. Another important aspect which I want to raise is that Islam also gives us the opportunity up to 1/3 of our net estate to whoever we want, provided that person is not an existing heir. So what we call in English, a bequest. In Sharia, we call it a wasiyah, and Rasulullah has said, a thuluth kathir, the maximum you can give is 1/3. So when we look at the will, as you can see, it embraces a lot of topics. It's not that, okay, I want to give this to my son, this to my daughter. No, you got to apply your mind what you are doing. One important aspect that many couples don't take into account in UK, a person gets married. Now you want to buy a house. It's normal. So you buy a mortgage. I won't discuss the issue of halal mortgage here. This is a different topic altogether. Now you will have two ways of doing that. Either it's going to be where the husband gets half, the wife gets half, or the other one is what we call the law of automatically when one of them passed away, it will go to the surviving spouse. Now this needs to be taken into account because a house for the average person might be the most expensive asset they have. There is also the payment of the mortgage, right? So very important to understand for the average person. I'm not talking of a rich person. I'm talking people like myself, the average people. We have a small house. We want to, to have a decent living, etc. The other one is you put what proportion you have. Say 20% for the wife or 40% and 60% for the husband. So these are the two matrimonial regime we have. That needs to be taken into account when we draft a will, because your matrimonial regime will supersede what you write in your will. Indeed. Because this is a contractual issue. So that also couples must take into account, right? The same way, if you have children, that also needs to be taken into account. If you got minors, if you close your eyes and you got minors, who are in charge of those minors? So there are many issues when we look into a will. But if you allow me, one important point I want to raise is understand what is a will. A will is a written, I'm laying emphasis on this word, a written expression of the testator or testatrix regarding how he wants his estate or her estate to be devolved after his death. I'm using the word written because the Wills Act is very clear about it. It got to be written. And there are conditions for that. There are exceptions for soldiers and this and that, but I'm not going to go into those details. So it has to be written. And I think this is a main point our people don't understand. We cannot give verbally. It got to be written. This is English law. If you want it to be upheld by this legal system, it got to be written.
Indeed. I'd like to go back to this situation of husbands and wives, because they may be husband and wife in the traditional Islamic sense, but they may not be husband and wife in English law. So when a will is written, and even if they're holding a house, as you said, I'm going to use the legal terms, joint tenants or tenants in common, even if they're holding the house like that, how can they ensure that the will is done Islamically, and that wife is also, if the wife is a surviving partner, for example, how can we be sure that she has somewhere to live for the rest of her life, as well as ensuring that it's done in the Islamic way?
That is a tricky question.
Sorry.
We need to look for a legal solution in that, even in the UK. Now, first of all, the couples must decide when they buy, because the solicitor will ask them how they want it to be, right? If they want it to be, as you mentioned, joint tenancy, there can be a provision for that in Sharia, in the sense that with joint tenancy, there is a rule of survivorship. Automatically, it goes to the surviving one. And this is where we have a conflict with Islamic law. So there are two ways of resolving this problem. One is you can apply to change it. It costs about 100, 200 pounds. If you want to do it, you've got to do it through a solicitor. I would advise it this way. Pay a professional, do it properly. The other one is, there is a fatwa I've seen in Malaysia, but under a different context. When the other party the surviving party receives it, there must be a clear intention that he receives it as an amana. Okay. Yani, that he has taken it as trust and he will give it to the heirs.
Understandable. Yes.
So there are two ways of looking at it. So either you make a tenancy in common, yani you put it right as it is, who get what, say 40% for the wife, and the other one is, say, for example, 60% for the husband. When they die, it does not go automatically to the other party, and then it goes in inheritance. And the other one is the surviving party takes it as an amana, because we got to look at the condition and circumstances, the law of the land. There are many other things to consider. It's just we say, no, this is not permissible, right? Okay, that's one. Going back to your first question, somebody who is married, nikah only. Now, there is a concept in UK law called cohabitation. So I know that there is a tendency to come with legislation with that, but nothing stops the people to have the house in a trust, right? And have this arrangement according to trust law. And an Islamic way, you can make a waqful ahli. It will more or less, there are 6 differences between a waqf and a trust. So this is another way that the couple have to understand. So they are not recognized as husband and wife, but cohabitation can, technically speaking, if we go to court, has an impact on the state. Couples fight on that,
Yes.
right? So we can sort this out as well while it's still alive. So the nikah is not recognized. They will be considered as cohabitees, but you can still have documents which will be recognized by the court. Because owning property, technically, it falls under the Lands Property Act.
Yes.
Which is a different law. It's not under family law.
Yes.
It falls under the land law, right? So we have to consider that as well.
It's very interesting. And then just to complicate a little bit more, in the UK we have what we call blended families. So there may be children who are not children of both the parties of the family. How do those children get dealt with under Islamic law?
Now, that also is a very emotional thing because, say, for example, you, for whatever reason, you brought up your nephew. There are 3 concepts in it. One is stewardship, one is adoption, and one is fosterage. There are 3 concepts that we have to deal with. From Islamic point of view, because this child has grown up with you, there is an attachment there. It's not your biological child. Under Sharia, if you remember in the beginning, I said that there is a concept of wasiyah, bequest. Bequest, you are entitled to give to whoever you want, up to 1/3 maximum.
Okay.
Right? So you got to use very intelligently what Sharia has given you and factor that under English law to protect that child as well. So you can use your bequest.
Okay, that's lovely. Let's talk about the different forms of wills that we might be able to have. So obviously there is the standard English will under the Wills Act, and then we have all the clauses that we need to consider from the Sharia. And I know that in the community people try to make this a hybrid will of some form. So maybe you could tell our listeners a little bit how those wills might work.
Yes. I think this is a burning question. I myself have tried to look for case laws. According to my readings, I have not seen a case law that whereby, for example, take a country like South Africa, we're qualified. There we just have to put, we wish that our state be divided according to Islamic law. A certificate will be issued by such Islamic organization, and we thereby approve of it. Okay. So there is this whole debate that you are dictating from your grave. Who gets what? Okay, this whole debate. But the entire will is like this. You're dictating from your grave.
Indeed.
Okay, when you die only, which is its effect. If not, it's not having any effect, right? You can change your will. So that is clear. But in UK, I have not found so far. There might be, I don't know. I'm talking subject to correction here. But we have a wonderful system, as I mentioned earlier on, the concept of freedom of testation. Subject to certain condition, we are entitled to give to whoever we want. Now, as a Muslim, first thing we have to understand is ourselves first. I would advise that at a normal standard will, we're going to have a revocation clause. You revoke whatever you have written in the past. This is a new one. That is, you got to identify yourself. You got to say yourself you're a Muslim. This is very, very important for burial reason. At times, I have seen, few times I have seen where people are married to Ahl Kitab, people of the book, and they don't want to give the body. And that becomes problematic. I have seen it personally, right? So have to negotiate because there are some rulings in Islamic jurisprudence how you bury somebody. So that is why I'm saying to mention that. You got to talk about yourself. You want to be buried ASAP because the Hadith of Islam, 3 things that must not be delayed. One of it is burying a person. Now, living in the UK, we have to be very careful. If there is a post-mortem, right? For example, a murder, whatever, may Allah protect us. In that case, what do we do? So you can also put there that you prefer an MRI scanning, if it is possible and if the law allows it, because you don't want your body to be mutilated, right? You want your body to be normal when you're buried. Another important point is the issue of organ donation. I don't want to go in the jurisprudence of it, that they can consider their own scholars, but NHS, you can go on NHS website, but I think as a Muslim living in the UK, we need to read all the things.
We do.
There is a shift now, whether you decide to give or the state can get it. There's some condition there, of course. Right?
Yes.
So
I mean,
these are things
you
that
can, sorry, brother, but you can register as an organ donor, but as
Yeah.
a Muslim organ donor, and there are principles that they know they have to adhere to if you say this. The difficulty that we have now is that if you do not register anything at all, then the state may decide that you're an organ donor.
Yes.
Yeah.
So this is why I think the Muslims must read about it, know about it, or about organ donation. So you get the post-mortem organ donation, where you want to be buried, because some people want to transfer the body to bury in their country of origin. Now that also is another fiqh issue. You go to France, I've seen that quite often. In fact, in France, they do have a Islamic insurance policy on that.
Oh, okay.
Yes, okay. So these are individuals. You're dealing with individuals, so that is about yourself. And number two, and I think again where we need to be very careful, we need to appoint an administrator or executor for our will. Somebody who knows our affairs, maybe our wives, our husbands, who knows what is our debt, etc. Once these things are sorted out, that is what you want your body to be buried as soon as possible, give you a good ghusl, etc. Though it looks to be a bit childish, what I'm saying, but when the person goes through it, when the family start fighting, then we'll understand what I'm saying. When this must be there, be clear about it. It's your body. It's your body. You have to decide this, right? So once this is sorted out, you know who will look after. The next thing, which is very, very, very important, and this is in the Quran, the debt. You got to make sure you have a codicil. Who do you owe? Not everybody, especially if you're in the business. Who owns what? Who you owe? Because Islamic law is very, very, very strict on that. You got to make sure it's being paid. So you pay it from your estate in case you die. Now, I always raise a very important point, which got to do with your first question about estate planning. Many times we do not care about HMRC.
But they care about us.
Yes, they care about us, right? Now, this is the right of HMRC.
Indeed.
If your estate is beyond your nil band rate, excuse me, then per person is 500,000. That also the law is going to change. I don't know when. About your primary residence, I don't know when the law will come. So as it is now, husband, wife is 1 million. You can transfer to your kids. But what is the problem is people came in UK in the 1960s. They bought a house for £30,000. Now, the same house is 500,000, 600,000 pounds. They don't realize this. So if they got two property, you're already above 1 million.
Indeed.
Okay? So people have to take this into consideration. That if you got property, you got assets, you got to value it property, make sure that you consult your lawyer or your whoever is advising you, that there is no impact of that. Because the moment you die, your death certificate is filed, and automatically HMRC will. It's normal.
Yes.
They will send a letter. Whoever have been appointed as your executor or administrator, it's normal. It's in the system, right? So we have to make sure that this is taken into account. One advice I always give people, the Muslim community, we know according to Islamic law, when a husband dies, the wife will have to sit in an iddat period, a waiting period of 4 months, 10 days. Please, please, please make a provision for your wife. Put it in her bank account. It's clear, this is her money, because we don't know what can happen after your death. You can die anytime. 4 months, at least, she got some peace of mind.
Yes.
Yeah. So people don't understand this thing. They treat it lightly, and death can come anytime. So once you finish with your debt, the next one, this is where we have this issue of, do you put a simple clause that I wish my state to be distributed according to Islamic law, a certificate will be issued by Mufti so-and-so or Jamiat or Darul so-and-so, stipulating who will be the heirs? That is one way. And that can be for the judge, say, look, I don't know Islamic law. How do I know this is true? That's the issue.
So they need to get experts' evidence, which then makes it
Because
very costly.
Exactly.
Yeah.
And this is where there was a case in the High Court. It's Islamic finance case, 2004. Begzimco case, they call it, right? Where there was a matter that went to court. It says it's got to be according to Sharia, according to the contract, the glorious Sharia. The judge said, we don't know what is a glorious Sharia. Where is your precedence, and so on and so forth. So we cannot do that. It's a British law. If you want us to understand, don't put a term there. We are not trained with that. Explain it properly to us.
Right.
So this is a well-documented case law, 2004, from the High Court. So this is where I think it will be, in the case of UK, to spell it out.
Yeah.
That is one way to
Yes.
spell it out. And you got to revise your will every now and then.
Yes.
One caveat I'm going to mention here to protect myself and to protect you as well. Any will can be challenged. Any will. So keep this in mind. Any will can be challenged. Okay? So you have to have it. Generally, maybe 1% of the wills will be challenging because it costs money, all those things, right? Because depending which court has jurisdiction on that, and the higher you go, the higher the cost. Okay? So not everybody challenge it, but hypothetically, keep this in mind. So this is why, my humble opinion, looking at the scenario in UK, one way is you do that. The other way, that is you spell out who gets what. The other way is, because you got freedom of testation, right? There was a case in 2017, very interesting case, where a father intentionally disinherited his daughter. He gave everything to a charity. The daughter was really poor, and she appealed against this. The court, if I'm not mistaken, gave her £200,000 because the father had to look after her, though she was an elderly person, she was really poor. So the court, in the name of justice,
Yes.
say that you had a duty of maintenance.
Yes.
Right? So we have to take the British context, right, as well. And this is what people don't understand, that we are living in UK, the court has a right to look at our documents, right? The moment you got a will, it become a public document. Once you put it a probate, it become a public document. Everybody can read it, yeah? So these things people don't understand. So this is one way, that is you stipulate who gets what. Okay. Number two, you can make a testamentary trust in your will. There, whereby you put everything in a trust and the trustee decides it, you give a letter of wishes. That is another way. But then you got to make sure the trustee is an honest person. If not, he can take everything another way.
They're truly a trustee.
Yeah. So you have to ensure that the trustee is a reliable person, right? Then, of course, people doing mirror will, etc., which are quite complicated. But for me, these are simple, straightforward things, right? If you can write a will, you stipulate who will get what. Then, after you do that, I would advise people something very important, what we call a residuary gift. God forbid, if for whatever reason, an entire family is wiped out in a car accident or whatever reason, a pandemic or whatever, what happened to that state? There can be prescription where the state take it. You can have a provision in your will. Should there be no heirs at all, I hereby donate everything what I have to this orphanage, for example, this charity, for example. At least after your death, it becomes a sadaqatul jariyah.
Yes.
Then, important for those who got minors, I've checked the law. In your will, you can appoint who is going to be the guardian of your child. That also we can do in a will.
Yes.
Cater for the child, because it becomes a social problem unnecessarily.
Yes.
So if you can facilitate that for society, it's good.
Yeah. Can I just say something? As a family lawyer, I just need to interject that if you do not name a guardian and there is no parent or parental responsibility on your death, the child goes into social services first before somebody's appointed. So if you want to keep your children out of the care system, you really do need to appoint a guardian in your will.
Yes.
Yes.
Thank you for raising to clarify this deeper.
Yes.
Yeah. After you finish this, a point I raised earlier on, this is where you make your wasiyah. After you have catered for your debt, you have catered for your family, etc., for your children, then you got to make a wasiyah. I don't know how much to lay emphasis on that. Allah subhanahu wa ta'ala has given us the opportunity here to make sure if there is any shortcoming in our salah, in our hajj, this was zakat, etc., we can make a provision for that. Or we can use it to make sadaqatul jariyah, make a well in a poor country, set up an orphanage. And that can go to non-Muslim as well. People don't realize this.
Right.
Yes, by all means, right? So we got to use this 1/3 because we don't know after our death what our heirs will do with our estate. So don't close our book of deeds. Don't close our book of deeds, right?
Indeed.
Okay. Then lastly, what I advise people to do is make sure there is an arbitration clause. I have discussed that with many lawyers. Can you impose an arbitration on your heirs? Because you got to have the terms of reference to sign it. I discussed it with judges as well. There is a difference of opinion. My gut feeling, again, I don't have a precedence on that to pronounce. Maybe there is, I don't know. But this is extremely important because children tend to fight. Children tend to fight, heirs tend to fight. They don't want, it's quite problematic.
Yes.
We deal with this, we know, right?
Yes.
So to avoid all the things, to avoid cause dirty linen, you must wash it at home. Don't make it become a public hearing, and we can sort this out. Then, of course, your will need to be signed by witness. The witness doesn't have to know what is in your will. They have to witness you who have signed it. You need to have 2 witnesses. You got to be 18 approximately, right? You know what you're signing. You are not being coerced to sign it. It must be well drafted. Get a lawyer to draft it. And your specificities must be spelled out. I would advise pay somebody some couple of pounds, not couple of pounds, couple of hundred of pounds to draft a normal will. Of course, if you got more than 1 million, then you have to see an expert in wealth management because there will be other things to consider. And if you want to to have a trust in it, again, is a lawyer who will do that for you. One point you raised earlier on, which is problematic, what about the wife? How do you protect the wife? Husband is 60 or 70 or 80, the wife is about 7. She's not going to work at this age. She's weak. I'm going to raise it. It's the difference of opinion among the ulama on that, but I'm going to raise it. The Hanafi position is the heirs will get whatever they get. And there is a hadith, la wasiyata lil warith. A person who is already inheriting, he will not or she will not get anything as a bequest. In the Maliki school, there is something called Umrah where you can, what we call in English law, interest in possession. So you don't become the owner, but you can stay in the house till you die. Till you die,
yes.
So at least the wife is protected.
Yes.
Now, as I mentioned, the difference of opinion, if you go in countries like Singapore, Malaysia, Brunei, it's in the law, written law. Okay, they are practicing it, right? With the Indo-Pak, there is some reluctance to accept it. There is one hadith in Sahih Muslim on that. I'm raising it because this is a genuine problem you have raised here.
Yes.
This is a genuine problem. I myself, people come to me with this. In Sahih Muslim, there is something on Rukbah and so on. Ulama will know about it, where you can give it, that's right, to benefit. However, after the death, it goes back to the original heirs. There is one hadith on that in Sahih Muslim. But then I will leave it to the fuqaha. I'm not a faqih, I'm not a jurist, I'm a humble student of deen. So I will leave it to the great scholars to decide this, because the circumstance in UK is different. We are not living in a tribal system when you die, the tribe will look after the wife or an extended family.
Yes.
In UK, we tend to live in a very cellular family.
Yes.
So we got to take all those things into account. So it's a very important point you have raised.
Okay. So you've mentioned a few of the clauses that ought to go into a will, the peripheral clauses such as your burial, your guardianship and so forth. Are there any other of those sorts of clauses that you think need to be included?
Yes. It's a very intricate question that you have raised. If you are a businessman and you want your business to perpetuate, right, that requires, if you are a rich person, that usually what you call the family office who deal with that, and that requires a proper structuring of maybe the trust mechanism we use, and many other systems we use. That requires a different types of trust that we need to do while you're still alive.
Right.
And if you want to keep the business within the family, that requires proper financial engineering here.
Right. Okay.
Right? Because who will be in charge when you go, the transfer of the shares, the shareholders agreement maybe needs to be relooked into, which will supersede the article of association of the company. So when a person is rich, that requires a different discussion. Maybe one of those days, if Allah wills, we can have
those.
For businessmen, we can have a show on that.
Inshallah.
But that is very, very important to look into.
Yes. You mentioned something about burial, and especially if the person is not married to a Muslim person. And I thought I'd raise a case. Lady Hale,
Yes.
you probably know the case. Yeah, yeah. She. There was a child who, I think he was from New Zealand or one of those countries, and he was taken here as a child, raised here with English parents, and they found out that he wasn't actually adopted with the consent of his family. So when he was found by his family, or he went to look for his family as an adult, and then sadly he passed away, there was an argument between his adoptive family and his birth family as to how he should be buried. And Lady Hell had to find the balance between, the traditions of the birth family and what the adoptive family wanted. And that's something that we should consider as Muslims, especially if we come from, multi-faith families, if we're reverts, or if we're married to non-Muslims and that sort of thing, because we need to be very clear about what we want for ourselves in our death.
Yes, I think that's a very important case law you raised here. I mean, it is interfaith marriage, intercultural marriage is on the increase.
Indeed.
Right? We cannot run away from it. If you look again on the statistics, we go on ONS website, we will realize that the level of cohabitation is increasing,
Yes.
and not marriage.
Yes.
People don't want to have financial responsibilities or whatever reasons.
Yes. Yeah.
And this is where the parliament, sooner or later, will have to look into it to protect people.
They have to. I mean, it's been before the Law Commission,
Yes.
and Resolution have been trying to lobby for a very long time.
Yes.
It's taken a long time to get there.
Yes, a long time.
Yes.
And why we don't have it, because maybe pressure from the family, from the culture, from the society. So they just live like this, so that
Yes.
nobody can pinpoint finger at them,
Yeah.
right? So, but it's a reality of things, right? From Islamic point of view, okay, the Quran is clear. You can get married to Ahl Kitab. That is mentioned in the Quran. And there are many Muslims who are married. Another thing which I maybe it's not appropriate because time is limited, where a person is married with officially a civil marriage, and then he has cohabitation, nikah. Yeah.
Okay.
Now that also, I mean, it's people's life.
Yes.
Some people want to make nikah, some people have mistresses, whatever the case. I'm not going to go into the details. That's people's life. We are not going to dictate people what they must do and not what they must do. But the reality, the ground level, they come to us with their problems.
Yes.
How do we resolve these problems?
Indeed. Indeed.
Because the wife who is civilly married, technically, she's the official wife.
Yeah. And has
And
automatic
then they
protections.
will- yes.
Yeah.
And then you'll get the religious, if I
Yeah.
can use this word, the religious wife. How do we attend to that?
Yeah.
She too is, Islamically, she too is entitled,
Yeah.
right? Islamically, she's in the wedlock, right? So these are practical issues that we deal with. People, before they die, they need to sit with the family, with the lawyer, the estate planner, whatever be the case, and put their ducks in a
Consider all
row.
these, yes.
Yeah.
Indeed. Indeed. I think I'd like to just, we've got a few minutes left, if we could just touch on other protections in life. So obviously there's the LPAs and deputyships. I wonder if you could just tell our listeners a little about those before we end.
That is, you want somebody to take over your property.
Yes.
Yeah, this, again, time is almost finished. We can have another talk show on that. So basically, if a person is not well, right, he has the potential to get into a vegetative state, and he wants people to run his thing, you can have a living will, right? So that person is taking responsibility. Under Islamic law, it becomes like a wakala, an agency type of thing, right? And the other one is the power of attorney as well, right? Power of attorney, I had to give a legal opinion on that. There's no time to go into detail. At times, power of attorney, from a Sharia point of view, can become problematic.
Right.
Yes. It depends on the age. You are usurping the right of other people or not. Right? So you tell the person to make a power of attorney, maybe you are not in a mental state to do that. And that is where the Mental Health Act comes into.
Yes.
Yeah. And again, I think it's a very, very, very important point you are raising here, because the level of dementia is increasing in this country.
Yes, it is. Yes.
We got to address this. And Muslim is not an exception to that, right? We have so many cases. So what I would advise people to do in that case, because again, as I mentioned earlier, a will can be challenged. While you're dementia, there are 3 stages. I mean, that's a medical thing, where the first stage, you still know what you are doing. The second stage, you forgot what you are doing, but the previous one, maybe you're still remembering. The third one, you don't know
You
at
have
all,
no capacity
right?
at all, yes.
So your legal capacity is affected. So while you are still in the first stage, I would advise people, when you draft your will, have your notary or your lawyer, who is an officer of the court, to certify that you are signing that knowingly, willingly, without any coercion, so that that document stands in court.
Yes. Yes.
So even you have a living will, nobody can challenge that will
Yes.
tomorrow.
Yes.
So I would advise people to do that. While this, for example, the doctor is telling them today. So as soon as possible, go and see a notary or a doctor. Make that a legal document that I know what I have done.
Yes. Dr. Manju, thank you so much. It was a
pleasure.
very, very interesting talk. I feel like we need to have a full lecture to help the community to truly understand their obligations and their rights as well. As they would have heard, that we need to ensure that their assets are well protected in life and after, they've passed on, and to ensure that their loved ones are taken care of, that the assets go into the right hand, and this is all done within Islamic principles. It's extremely important. So thank you, listeners, for tuning in. This is Radio Ramadan on 87.7 DAB and FM.
Thank you very much.